on probation in these 3 cases.
Last week.
Yeah.
And obviously she doesn't understand the significance of what is being held over her head. I don't know that I would offer to keep her on probation based on that without some kind of significant cognitive treatment.
Good morning. Are you Edwinia Johnson?
Yes, ma'am.
And Ms. Johnson's here in cause numbers 24 DCCR 2151, 2152, 2153, and then there is also cause number 25 DCCR 1826. And the first 3 cases are all probation cases that Ms. Johnson is currently on, and there's been a motion to revoke filed in each of those. The underlying offenses are forgery, abandoning or endangering a child in the other 2, and then that new offense is for robbery. Ms. Holmes filed a motion asking for me to set bonds in those 3 underlying motion to revoke cases. She's on deferred, but I set it for a hearing based on that underlying offense. I want to know really what's going on before I figure out an amount or if I'm going to set bond. So, Ms. Holmes, I'll let you go first. You're going to call your client for purposes of...
Yes,
Ms. Johnson, best you can, raise your right hand. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Thank you. You may proceed.
Okay, you Edwina Johnson.
Yes.
Okay, Ms. Johnson, how long have you been in custody at the Jefferson County Jail?
8 days.
Okay, and you're in there because you understand that there were motions to revoke probation due to allegations that he's violated probation, correct?
Yes, ma'am.
Now, the alleged offense of robbery is one of the underlying allegations. You're understanding of that, correct?
Yes, ma'am.
In which the offense date was not very long after you were placed on probation.
Yes, ma'am.
Okay. We've discussed that. While you have been in custody, we've talked about you wanting to get back on track with probation, and while all of this is pending, correct?
Yes, ma'am.
Now, if the judge was to set a bond, where would you be residing? You don't have to give the exact address, but would it be in Beaumont?
It was in Beaumont.
Okay. Okay. And you have family who have obviously reached out to me who would be supportive of you to make sure that you come to any and all court proceedings and that you do whatever is necessary, and that you understand that if you are given bond, that there may be certain restrictive measures such as GPS monitoring, things of that sort, placed upon you.
Yes, ma'am.
Okay. And are you asking the court to set reasonable bonds in your cases so that you can hopefully be released and try to get back on track with probation? It doesn't seem that you got very far with starting probation because you hadn't been on it very long. Is that
Yes,
correct? Okay.
This is a moment every courtroom watches for in silence. Once the judge starts reviewing probable cause, the emotional arguments stop mattering as much. Now it becomes about risk, accountability, and whether the court believes a defendant can follow rules outside jail. And remember, this was not years into probation. According to prosecutors, this alleged robbery happened just 1 week after probation started. That timing alone is a massive red flag in court's eyes.
You can try to get back on track with that.
Yes, ma'am.
I'll pass the witness, Your Honor.
No questions.
All right. Any other witnesses?
No, Your Honor.
Mr. Smith?
Judge, because they're deferreds, I believe that you have to set a bond. We would request those be fairly significant bonds. The underlying offense, even though it's not with strangers, it's people that she was living with. There was an argument, it turned violent. This defendant did not live there, but she was there. She gets in on it, holds her down while they take this other person's phone, ripped it right out of her hands. So this is 1 week after she went on probation in these 3 cases.
Last week.
Yeah.
And obviously she doesn't understand the significance of what is being held over her head. I don't know that I would offer to keep her on probations based on that without some kind of significant cognitive treatment so that she would understand how to make better decisions. But we would request those bonds, like I said, to be significant.
So probation started in all 3 of these cases October 6th of 2025. And so probation's here. And ma'am, would you raise your right hand, please? Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Thank you.
Notice how the judge immediately shifts to the children. That is not random. Judges often look at family stability when deciding bond conditions because it helps determine whether someone has community ties and a support system. But at the same time, you can hear the concern in the judge's voice getting stronger. Being accused of violent offense only 7 days into felony probation? That is the kind of detail that can completely destroy the court's confidence. What do you think? Should someone get another chance this quickly after allegedly violating probation?
And so were you able to have any meetings with the defendant, Ms. Johnson?
Yes, ma'am. I met with her in October when she first got placed on probation, and then again in November. But when the offense occurred, she then reported to me when I met with her in November, and that kind of was alarming to me. And then also in November, she told me that she was in Houston. No, I'm sorry, I think that was December. She went to Houston without letting me know first. So that was also another concern. And so there may be some compliance issues with that.
Okay. Ms. Holmes?
Well, Your Honor, based being that she's on deferred, we would ask that a reasonable bond be set. I do understand the concerns of the department and the state, being that she wasn't on.
And there it is. The judge makes something very clear here. These are still allegations, not convictions. But bond hearings are not about deciding guilt. They are about risk. The court is asking, can this defendant safely return to the community while the case moves forward? The $50,000 bond instantly tells you the judge believes the situation is serious. The courtroom probably knew at this point that any release would come with heavy restrictions.
Probation very long at all before the new alleged offense occurred. And with speaking with Ms. Johnson, she is realizing the severity of the cases that she is on probation for, and she has expressed to me that she wants to get this right and get back on track with babies.
For the record, I'm reviewing at this time the probable cause and the underlying offense. Give me just a second, please.
The judge is reviewing probable cause right now, and this is a huge turning point. Emotion leaves the room. Facts take over. Did the defendant earn another chance or lose the court's trust? I'll read it.
Who's taking care of your kids, Ms. Johnson?
My brothers and sister, and the boys are with their father people. It's like,
Okay. Obviously, it gives me a whole lot of concern that she was on probation for a week. Obviously, they're allegations, but they are serious, and it shows a lack of concern for being.
This is what courts call a structure release. Technically, she is being given a chance, but it is a highly controlled one. GPS monitoring means a court wants to track every movement, and house arrest means freedom is extremely limited. One violation: missing curfew, tamper with a device, going somewhere unauthorized, and she could land right back in jail fast. The judge is basically saying, I will allow release, but only under constant supervision.
3 felony probations. So I am going to set bonds, but in cause number 24 DCCR 2151, I'm going to set that bond at $50,000. And then I'll go over conditions in just a minute. Cause number 24 DCCR 2152 and 2153, set each of those at $25,000. Order as a condition of bond if it is made that there will be a GPS monitoring device and Ms. Johnson would be on house arrest. So I would have to know an address, who is living there, and she would be required to remain at that address other than visiting an attorney or coming to court, and be required to pay the cost of that GPS monitoring device, keep it on at all times, keep it charged at all times. Obviously have absolutely no contact or communication with Isis Martin, who I believe she's out, right? She was here yesterday.
This part is bigger than many viewers realize. No contact orders are taken extremely seriously because they're designed to protect witnesses, victims, and the integrity of the case itself. Even indirect communication, texting through friends, social media messages, or accidentally showing up somewhere, can become a new violation. The judge is drawing a hard boundary here. Zero contact, zero excuses.
Smart sounds familiar.
That's
Anyway. And then also no contact with Harmony Boatner, and not to be at 901 Main, anywhere near that address in any of the apartments. Is that where anybody that you plan on living with lives? Okay, so you're not supposed to be, you won't be able to be obviously anywhere around there because you'll be on house arrest. But specifically, you cannot have any contact or communication with the co-defendant, with the complaining witness, or anybody that has anything to do with this. That means in person, but it also means sending messages or sending messages through other people or anything like that. Do you understand?
Yes, sir.
All right, we'll get it set for an announcement on the motions in the case then.
Yes.
All right, you can go back with
Bonds
the
are set. GPS ordered. House arrest imposed. That means release comes with strict control. The court is giving a chance, but with zero room for mistakes.
And that final line perfectly sums up this hearing. The defendant avoided being completely held without hope, but this was not a victory lap. This was the court extending a very fragile opportunity under strict control. One bad decision allegedly led to the situation only days after probation began. Now the margin for error is basically gone. Do you think the judge balanced punishment and opportunity fairly here? Or should the court have denied bond altogether?